Maintenance granted to wife in a null marriage. Justice D.M. Dharmadhikari and Justice H.K. Seema of the Supreme Court noted in the case Ramesh Chandra Ram Pratap Ji Daga versus Rameshwari Ramesh Chandra Daga that even though the marriage was null, still the wife and daughter are entitled to maintenance, and the court upheld the judgment of the High Court related to grant of maintenance to wife and daughter, and the decree of declaring the marriage to be a null marriage while dismissing the appeals. Appellant Ramesh Chandra Ram Pratap Ji Daga and respondent Rameshwari Ram Pratap Ji Daga were married and had a daughter out of the marriage. And prior to this, the appellant, who was an income tax practitioner, was married and had 2 sons out of the first marriage. Thereafter, his first wife deceased. It was alleged that respondent who was getting married to another man, the customary rituals of marriage went incomplete due to the fight between families, leading to her filing of divorce petition which was pending. It was alleged by respondent that as per the custom prevailing in the Maheshwari community, the marriage got dissolved between the respondent and her earlier husband by way of chorchitti, whereafter it got registered. Also, it was alleged by her that the appellant was shown the document and then they got married, and she further alleged that she was not treated well because her father could not fulfill the demands made by the appellant, and later she was sent away from home. Respondent filed an application for judicial separation and claimed maintenance for her and her daughter before the Family Court, Bombay, where the court granted a decree of judicial separation, maintenance of ₹1,000 per month for respondent and ₹2,000 per month for daughter. So, the appellant filed an appeal before the High Court, where the court declared the marriage to be null and void as per Section 11, read with Section 5 Clause 1 of the Hindu Marriage Act of 1955, while maintaining the grant of maintenance to both the respondent and her daughter. This led to the filing of appeals by both the respondent and the appellant before the Apex Court, where the court observed. In the case of Chandavan, a joint petition filed by the spouses for grant of a decree or divorce by mutual consent failed, as they withdrew their consent during the statutory waiting period. Thereafter, the wife moved a petition for grant of maintenance under Section 25 of the Act. This court held that Section 25 can be invoked either of the spouses where a decree of any kind governed by Sections 9 to 13 has been passed and the marriage tie is broken, disrupted, or adversely affected by such a decree of the court.